with regard to Ukraine, we're already up to around some 10,000 deaths. So it's not like this thing started yesterday, and it's a complicated situation. So I think that the government of Ukraine has done something which makes a lot of sense, and that is to resort to the rules that are spelt out in the United Nations Charter and the statute for the International Court of Justice, which provides a means, or ways and means for countries to resolve issues in a peaceful manner. This is a peaceful settlement of disputes. And by seeking to bring this issue before the International Court of Justice, even if it's on an interim or provisional basis, that is, I think, a very responsible thing to do in the interests of its citizens and of its own interests. So what is it seeking? It's seeking a wide number of, it's basically cease and desist of financing of terrorist activities with regard to Donetsk and Luhansk. And also that the rights of the Ukrainian minority in the Crimean Peninsula, as well as Tatars, are respected fully in terms of the full range of human rights that are respected under the Ukrainian Constitution, and as well as under the Russian Constitution, since it's occupied. Provisional measures are intended as an interim solution to prevent, as I said, further deterioration in the situation, so that there's not a prejudice to one party or the other. So it's to try to preserve the status quo, or to make sure that things don't get worse. But that does not preclude the court from ruling that it later on feels that it doesn't have jurisdiction over the matter, or even if it does have jurisdiction and agrees to take the course, because there are preliminary phase to determine whether it has jurisdiction or not, that eventually decides that there's no case made out that that it has to rule on. So it is not in any way indicative of what the court could do in its later phases. But as I say, it sends a clear signal, and I think tactically it's an important maneuver for the Ukraine government to do, and I think it makes sense. And I hope it's something that the Russian Federation also welcomes, because it has said that it's not involved in Ukraine on many occasions, at least in the way that it's been accused of or alleged to have been. And this would give it a chance to, if it's it's strongly committed to the international rule of law, as the Russian Federation always has been, to make its case out, clearly, transparently, that it has no involvement in Ukraine, or very, very little in some way. But it has to then answer the case. If the Russian Federation chooses not to take part in the proceedings at all, I think that will be a very bad sign. It will reflect very badly on the Russian Federation. So what I would hope for is that both Ukraine and the Russian Federation continue towards a dialogue, whether it's through judicial means and through the political negotiations, to make sure that the Minsk agreements are resurrected. They're in pretty bad shape, and also to find a solution to the issue that's agreeable to all sides, because the war is never a good thing, and it's ordinary people that are getting hurt. And so one of the issues in provisional measures is that if you look at the Terrorist Financing Convention and the Convention on the Elimination of Racial Discrimination, which formed the bases for Ukraine's claim against the Russian Federation. These conventions require that before you go to the court that there should be some serious negotiation first between the parties. And that has happened with regard to Donetsk and Lugansk. There's been the Minsk I and Minsk II agreements, and quite a lot of negotiation, very hard bargaining going there. But you haven't had very much on Crimea. So that is one of the conditions for the court doesn't want to go and order provisional measures on the basis of one or other or both of those conventions, unless the other avenues have already been exhausted. So the formula, I think, is serious negotiations have to have taken place already.